Employment law involves the rights of employers and employees when an employee is typically either fired or demoted. What most employees don't understand, and what we try to explain up front, is that Texas is an employment at will state. And by employment at will, that means that an employee can be fired for any reason or no reason at all. Typically, employees think that there must be some sort of probable cause to let him go, but that's not the case. There's nothing in Texas law that says that an employer has to be reasonable or that they even have to be careful in the decision that they make when they decide to discipline or terminate an employee. The employment at will doctrine, which says that an employee can be terminated at any time, has several exceptions, and one of the exceptions is if you have a contract. If you have a contract that says that you're employed for a year, that can't just terminate you at will. The other exception, and the exception that we handle a lot of, is if an employer discriminates against an employee, and discriminates against an employee based on their color or their race or their national origin, their gender, their age, or sex. And sex necessarily includes sexual discrimination, that is because it's a male or female, or sexual harassment. And sexual harassment has some subcategories, which includes a hostile work environment or quid pro quo. Quid pro quo is typically when you have a situation where a manager comes in and says, if you want to advance in the workplace, then you have to do something sexual in nature. Hostile work environment is the typical situation where a manager or a co-employee does sexually oriented things in the workplace.